Good morning, everybody. My name's Andrew Daly, and I'm a partner and the head of procurement at Hempsons Solicitors. For those of you who don't know, Hempsons are a specialist health and social care law firm with 5 offices around the country, and we're proud to support and sponsor NHS providers. And I've been given 25 minutes to talk about the significant procurement law changes in 2024. So the conference theme is vital. I would argue that this is vital for everyone to know, but that's me as a procurement lawyer. Question if everyone feels the same. So, as I say, 25 minutes to talk about the biggest changes I think there's ever been in procurement is a bit of an ask. So this is a whistle-stop tour. There is more information available if needed, but 2024 will be the year of change in procurement. There are 3 things that are going to change. The first 2 are the most important. They are the legislation that underpins the whole of procurement. So we have the Procurement Act that will come into force anticipated in October 2024, and that will replace the current Public Contracts Regulations 2015 to change how goods, services and works are procured by contracting authorities. The provider selection regime is also going to come into 2024 subject to parliamentary approval, and that is for a new specific regime for the procurement of relevant healthcare services by relevant authorities. And subject to parliamentary approval, that's the 1st of January, so about 6 weeks away. And then finally, the thresholds for the application of the public contracts regulations are going to change on the 1st of January, and we're going to cover those just at the end briefly. It is important to stress that until the law changes, you should be applying the current law. I know that goes without saying, but it is important to remember. Now, we're going to concentrate on the provider selection regime. The reason being that it's coming into force the soonest, on the 1st of January, assuming it gets parliamentary approval. And it's important to note that this applies only in England. So if you are from somewhere outside of England today, this will not apply to you. The key documents for the provider selection regime are set out on the slide. We have the Healthcare Services Provider Selection Regime Regulations 2023. They were published and laid before Parliament on the 19th of October. And then we have the statutory guidance and the implementation toolkit. And we're just going to quickly go through that. We at Hempsons have been heavily involved in the implementation of the provider selection regime, having been advising NHS England for the past 2 and a bit years on the new regime. The regulations have been led by the Department of Health and Social Care, but we, along with NHS England and NHS England Legal, have inputted into those. We then have helped draft the statutory guidance and the implementation toolkit. So we feel that we are in a good place to explain what the new law will be, having advised on it for the past couple of years. So what is going to happen? Well, once the PSR regulations come into force, you will have a new bespoke regime for the procurement of healthcare services. So you will be, the healthcare services will be taken out of the Public Contracts Regulations 2015, and the Procurement, Patient Choice and Competition No. 2 Regulations 2013 will be repealed, and you will have a new standalone regime for the procurement of healthcare services. Who does it apply to? It doesn't apply to everybody. It only applies if you are a relevant authority, and relevant authorities are set out on the slide. They are NHS England, Integrated Care Boards, NHS Trusts and Foundation Trusts, and local authorities or combined authorities. So having drafted the regulations, the Department of Health and Social Care can't actually use them. They continue to have to comply with the public contracts regulations. When does it apply? It applies when you're procuring relevant healthcare services. So it doesn't apply to all healthcare services, it only applies to those that are defined in that. and that is defined in section 150 of the Health and Social Care Act 2012. So it is to individuals, and it is also you have to fall within one of the CPV codes, the Common Procurement Vocabulary Codes, that are listed in Schedule 1 of the regulations. There are provisions that deal with what happens if you have a mixture of contracts, some that are healthcare and some that are not, and that is set out in Regulation 3 of the regulations, and as a test you need to work through, effectively which is the higher value, and can you justify them being combined. There is no minimum threshold for the application of the PSR. So if you look at the public contracts regulations now, there is a requirement to advertise only if you're above a certain value. That is not the case under the PSR. It applies to a contract of any value. And it also needs to be clear that it applies to contracts between NHS bodies. It doesn't apply if you are procuring goods, social care services, non-healthcare services, but as I say, there are the provisions that deal with mixed procurement if that is what you are considering. The provider selection regime is not a free-for-all. You do have to apply some procurement principles when you are considering who you are going to award your contracts to. The most important of those is set out on the slide, that you must act transparently, fairly and proportionately. So you need to, that's similar to what we have now, slightly different test, but you need to make sure that you are not discriminating against particular providers, particularly based on whether or not they're public or private sector. If you fit within the provider selection regime, you then have a much more flexible decision-making processes available to you than you do currently. So currently the standard position is if you are above a certain threshold, you are required to advertise unless you can justify minimal exemptions. Going forward, you will have a number of different options available to you, and they're on the slide. I could talk to you for about an hour if I had the time about how these work. I don't. But the direct award processes, direct award process A and direct award process B, are procedures that have to be used in certain circumstances. Direct award process A is where there is an existing service and you think that or are satisfied that the person who is providing that service is the only person capable of providing it going forward. If that is the case, you must use direct award process A. It is not, though, capable of being used where there is a new service. If you're starting a new service, you can't use this. Direct award process B deals with patient choice, and if you've got a patient choice service, that must be procured under direct award process B. But to be perfectly honest, A and B are nice and simple. If you can meet the test, you award the contract and then you just tell the market you've done it. Very simple process. Direct award process C and the most suitable provider process are the new processes which are causing the most interest amongst commissioners, although you're not called commissioners anymore, but you know what I mean. Direct award process C is one that's causing a lot of interest because if your existing provider is doing a good job, you expect that they will continue to do a good job based on key criteria and basic selection criteria going forward, and the service is not changing considerably, then you will be able to award a new contract to that provider. There is quite a lot of detail as to what is a considerable change, but that is something that is potentially going to be very advantageous when procuring healthcare services. The most suitable provider process is also the new process, the one that everyone was looking forward to coming in. It has to be said it is not as flexible as had been initially anticipated, but if you consider that you can determine who is the most suitable provider, you can award a contract without a competitive process. There is procedure that you need to go through, and that includes publishing a notice to say this is the process you are going to run, which allows other providers to put their hat into the ring if they want to provide those services. But if you then can look at the people who are in the ring and decide who you are going to award to without competition. And finally, there is the competitive process. That is basically what we have now with a few tweaks. I think the thing to stress, and this is contrary to what HSJ would have you believe if you read their article, competition is not dead. If you want to run a competition, provided you don't fit within the criteria for A and B, there is always the opportunity to do that. Whether or not people will or they will use the flexibilities, we'll have to wait and see. But competition is definitely not dead, and if you are procuring a framework, you need to use a competitive process anyway. A nice simple flowchart for you. This is taken from the toolkits produced by NHS England, and this just gives you an idea of the decision-making process you have under the PSR. If you are considering processes under Direct Award Process C, the most suitable provider process and the competitive process, you're required to consider the key criteria. The key criteria are on the slide. They're very high level on the slide. They're a lot more detailed in Regulation 5, and then Annex D goes into far greater detail as to what the criteria mean and how they should be applied. The guidance states that the higher value the contract, the higher the expectation is that you will use a greater weighting for the value criteria. And it is also the case that you need to consider social value under the social value guidance published by NHS England under the social value key criteria. But it is up to you to decide how to assess those, and they should be built into your procurement cycle, your commissioning cycle, as to how you are going to make your decisions. The bit that most people are interested in is, well, so what? If I don't do it, what's going to happen to me? And what might happen is set out on the slide. If you are awarding a contract under Direct Award Process A or B, there is no standstill period and there is no PSR review panel. You go straight to judicial review if someone wants to bring a challenge. So there is still a risk of a court process. If you are using Direct Award Process C, the most suitable provider or competitive process, including when you're calling off a framework via a mini competition, you have to have a standstill period similar to that which you have under the public contracts regulations. You cannot award the contract until the standstill period ends, and the standstill period ends at the end of the 8th working day. So this is getting us looking ahead to the Procurement Act, where we'll be in working days for the standstill period, we're in working days for the PSR. During that period, any provider who meets certain tests can ask you to review your decision as to whether or not you have complied with the PSR. If no representation is received, as you can now, you just crack on and award the contract. But the review process that we have now for Direct Award Process C, the most suitable provider and competitive process, is effectively, if a representation is received within those first 8 working days, you are required to review your process, effectively mark your own homework, and say whether or not you think you complied with the requirements of the PSR. And after you have made your decision, whether or not you carry on, rewind or abandon, you are required to give the supplier who made the challenge and your winning supplier 5 working days notice of your decision, and in that 5 working days notice, if they make a representation to a newly formed PSR review panel, then the expectation is your standstill period will be extended while the PSR review panel review it. This is a completely new concept for these kind of services because this is a panel that is the first port of call if you want, as a challenger, someone to see whether or not they think the PSR was followed or not. The panel will give advice to the relevant authority. Now, a lot of detail on the panel is still to be published. Work is going on at the minute, but once it is published, there's expected to be acceptance criteria as to what the panel will review and what it won't. But if the panel reviews the process, it then will give advice to the relevant authority as to whether or not the panel thinks the relevant authority has complied with the PSR. And at that point, the relevant authority needs to make a new decision, that is whether or not they continue, rewind or abandon, and then there is a 5 working day period again between which you notify people and can actually then progress to do whatever it is you've decided to do. And there is always the risk that there is a risk of challenge under judicial review. Now, judicial review, a supplier may argue that you have acted irrationally or unreasonably, you've acted ultra vires, or that there's been procedural impropriety. That is a risk that you have. That's a risk that you have now, but it's not used because you've got the public contracts regs remedies. Going forward, judicial review will be the way to go to court in order to challenge the PSR. It is worth saying that making the the relevant authority review its decision or go to the panel is going to be a lot cheaper than going to court. But we're just going to have to see what that means for the number of challenges and how many people go to JR. There are some detailed transitional provisions in the regulations, and this basically says if you've started a process now, you continue that process under the PCR. If you start a process after the 1st of January, or the 2nd, given not many people will be working on the 1st, on the 2nd of January, then you apply the PSR. The interesting bit is the 3rd bullet point on that slide. If you are varying a contract from the 1st of January onwards, you vary that under the PSR, not the PCR. So that is a change. There are still rules and provisions on the contract modifications. I can see people taking pictures. These are all available on the NHS England website if you want to have a look. But I've not got time to go through this. This is how you make modifications, and it's very similar to what you have now. And then we have the statutory guidance. This is the guidance that NHS England has published with the intention of giving a steer and help as to how to apply the PSR regulations. And once it's all approved, you must have regard to the statutory guidance once it is published from the 1st of January onwards. The draft is available now. The guidance is split into a number of parts. There's the main part which deals with the regulations, but then there are some specific annexes that will be useful depending on your specific roles. So Annex B talks about transparency. There's a lot of transparency required under the PSR. There are 16 schedules in the PSR, of which 13 deal with transparency. So there's a lot of transparency. There's not as much transparency as there will be under the Procurement Act going forward, where there is a notice for near enough everything. If you are dealing with primary care, then you need to look at Annex C. Annex C sets out how NHS England considers the provider selection regime should apply to the award of primary care contracts. As I've said earlier, Annex D deals with the key criteria, and then Annex E, contract management, and Annex F on the transitional arrangements. To give you an idea of transparency, there are the number of notices you might need to publish depending on the processes that you are running. The freedom that the PSR has brought you with the flexibility in not having to have a default of advertising means that there is greater transparency as a result. And then there are toolkits which NHS England again has produced. The link to those is on the side of the slide, and they set out how, the same position just in different ways. So there's the frequently asked questions, and they're being worked up as more questions are asked by the system. There are process maps, there are flow charts, there are slides. So NHS England is running slides, running webinars. We're running webinars. To be honest, anyone who knows anything about procurement is running webinars about what this means. And then there is the FTS guide. The FTS guide talks to you about how you submit your notices under the PSR using the existing notices you have to use under the PCR. So that is an important document that needs to be looked at. So what do you need to know about the PSR? I've tried to summarise it in a few bullet points. The first thing is to make sure that people internally are aware of this. This is a massive change for the procurement of healthcare services. It will change how decisions need to be made. and you are going to need to embed these new requirements into your decision-making processes. The last bullet point, your governance is going to have to change. If you have an internal review panel reviewing what you have done, you need to have someone independent on that panel who was not involved in the original decision. Who are you going to have as your clean person who has not been tainted by what has happened and is able to look at that in review internally? You then are going to need to consider the most appropriate decision-making process. It is not a one-size-fits-all approach. There is different approaches depending on what your service is, but it is safe to say that processes that are currently high risk will continue to be processes that are high risk under the PSR, because they're high risk because of the nature of the suppliers and their willingness to challenge, not necessarily the process that you are running. The procurement principles must be applied. The procurement principles, it's fair to say, are not getting the level of publicity you might expect. It is all around how things are more flexible. Yes, they are flexible, but only in compliance with those procurement principles to be fair, transparent, etc. The key criteria need to be considered. It is a new way of making decisions, and those key criteria need to be embedded within your decision-making process. It's not something just to think about when it comes to award, because if you want to use the most suitable provider, for example, you need to make sure you've embedded those key criteria into your commissioning cycle. And as is the case now, there is a massive emphasis on maintaining audit trails. So you are going to be able to need to justify your decisions, and to do that you will need an audit trail. The remedy of judicial review, you need to show that you have acted reasonably and you have followed the process. If you don't have an audit trail that you're required to have, you're not going to be able to defend your judicial review. So it should be something that is of critical importance. And I can't stress enough the need to update your governance requirements, update your procurement policies, update your SFIs to deal with this change from the 1st of January going forward. And then just to finish off, the new thresholds are on the slide. The new thresholds are normally the big news at this time of year, but to be honest, they're the poor relation this year because of the bigger changes that have been announced. The new thresholds are on the slide. They're up there. They've gone up not much, about £1,000. They're inclusive of VAT, but the light touch regime threshold has not changed. But of course, from the 1st of January going forward, if you are procuring healthcare, you're under the PSR, not the light touch regime anyway, and that doesn't have a threshold as we've discussed. So if anyone would like to talk to me in depth on this, on stand 37, just down there. You can also have your caricature done while you're chatting if you like. But thank you for attending, thank you for listening. I hope you found that useful. There's my ugly mug and contact details if anyone wants to speak to me directly. And does anyone have any questions? And if you do, I can join the silent disco.
Hi there, I'm David from New Market Strategy. So I was previously a commissioner, so would have been delighted by this and that I could extend contracts that I thought were doing well. In my new job, I'm advising a lot of independent sector organisations that want to break into the NHS market, and they're worried that actually this is going to mean that contracts are just going to be extended. They're not going to get access to those markets. If you were an independent sector provider, how worried would you be by this, or what opportunities do you think it would bring?
That's a really good question. Oh, I can hear myself. That's not good. I think we're not sure is the honest answer, because there are some relevant authorities who will see this as the opportunity just to extend existing contracts or award new ones to existing providers and not run competitive processes. There are others who think that competitive processes are actually a good thing, and there's everyone in between. So it is clearly a risk to new entrants trying to get into a market that there are going to be less competitions, but I think what you would do is you would make sure that you would write or contact a relevant authority and say, if a specific opportunity comes up, we would be interested, because that then gets you, hopefully, considered as a most suitable provider. Now, of course, I can't guarantee that means you'll be successful, but at least you would be in the game. But how ICBs, NHS England, combined authorities and etc. apply this is yet to be seen. I'm going around the country with NHS England introducing this at their various roadshows, and when you speak to people, ICBs in particular have very differing views as to what this will mean in practice. Some don't like the idea of being able to make direct awards and use the most suitable provider. They want competitive processes. Someone yesterday was saying that without a competitive process, they wouldn't have their new excellent provider in the game. They wouldn't have even been considered. So everyone will be different, but it's a little bit like now. Not everyone runs tenders when they're meant to now, so the same, I think, will apply going forward.
It's always coming from it from a different angle. Where you have an independent sector provider in place at the moment, could you see the preferred supplier approach, or most suitable supplier approach rather, being used to unseat them? So if you had an NHS provider that said, well actually, because of their position we can provide a more integrated service, which an independent supplier couldn't do, then them losing the contract and being in a less good position to retain that contract.
Well, I think if you had that scenario, the relevant authority would need to use either the most suitable provider or the competitive process, because it would be changing who was going to be providing it. So you wouldn't be in the direct award processes. Then I think if you are unseating a private or independent sector provider who has been doing a good job for you, that would be relatively high risk, because you would have to show why a new provider, an NHS provider for example, was better than the private provider, whether or not that is through a most suitable provider assessment or following a competitive process. And that would be high risk for a relevant authority, because there would always be the risk that the independent sector provider could say that effectively it was a stitch-up. They hadn't complied with the procurement principles, they hadn't complied with the key criteria. So I'm not saying it might not happen, but you would be quite a brave, relevant authority to do it, because really what you want to be doing is encouraging everyone to work in an integrated way, no matter who they are, rather than just saying it is the NHS and only the NHS. Any more? Okay, so thank you all for coming. It's much appreciated. If you do want to speak to me, I'm down on the Hempsons Sky, and I think there is a feedback form. So if it's good, please scan that QR code. If you thought it was awful, please go and get yourself a coffee. So thank you very much.